Thank you very much indeed for joining us.
At KBC Channel 1 News, at Purity_Museo at Tomboya24, the hashtag is Prime Edition. Talk to us. We are also live on all our social media platforms.
Our top story, the hearing of the BBI appeal that kicked off at the Supreme Court Tuesday with Attorney General Paul Kihara seeking court orders to set aside decisions of the Court of Appeal as well as the High Court that civil proceedings can be instituted against a sitting president.
Kihara also wants the Apex Court to pronounce itself that a president can initiate a popular initiative as denying him the same was infringing on his constitutional right.
The first day of the hearing of the Constitutional Amendment Bill 2021 appeal at the Supreme Court on Tuesday kicked off with a ruling by a 7-judge bench led by the Chief Justice Martha Koome. All parties were allowed to have 15 more minutes, allowing those willing to donate time to do so too.
Taken in the currency.
The Attorney General, who was the first appellant, will seek for the Apex Court to clarify what the basic structure is and whether it's applicable in the Kenyan Constitution. Represented by Solicitor General Ken Ogeto, the AG says the judges did not agree on what the basic structure is and if it's applicable in Kenya.
Even if the basic structure doctrine was applicable in Kenya, which we dispute, the absence of clarity on what the basic structure is would create much legal and constitutional difficulty.
They will be supported with a number of respondents represented by the BBI Secretariat, National Assembly, Senate, among others.
And the words I would use to describe the basic structure doctrine is that it is a very unruly horse, and once you get astride, you will never know where it is going to carry you.
And Samuel Johnson convinced those with whom he was having an argument that if you want to prove that a stone exists, just kick it. Don't involve yourself in an argument whether the stone exists or not. So in this, the question that is before the court is as to whether the impugned provisions of the constitutions are amendable or not amendable.
Justice must not only be done, but must be seen to be done, and the courts of law ought not to interpret and apply the law in a manner that would lead to a predetermined outcome.
On whether the president can initiate a popular initiative, the Attorney General argues that the provisions of the Constitution do not discriminate between private citizens, which includes the president.
If you look at Article 24, which is the only one that deals with limitation of rights, it says a right or fundamental freedom in the Bill of Rights shall not be limited except by law, which means there would be a law that then limits the president's rights, because there is no dispute that the president has the right to vote. Why would we take his political rights to participate in a political cause?
On presidential immunity from civil proceedings, the Attorney General is against a judgment by the Court of Appeal and the High Court seeking the head of state to be insulated while discharging his constitutional mandate. The appellants arguing that subjecting the president to civil proceedings amounts to compromising the security of the nation, as it will give enemies fodder to their action. The Independent Electoral and Boundaries Commission, IEBC, contesting the ruling that the Court of Appeal and High Court on unconstitutionality of statutory provisions and decisions in relation to the mandate and its quorum. Well, the first day ends with the first two appellants having highlighted their submissions and also the supporting respondents to their submissions, with now remaining is just one appellant, who is Morara Omoke, among other respondents that are expected to highlight their submissions in the remaining 2 days before the 7-judge bench of the Supreme Court. Serafina Robi for Prime Edition.